We have very many young people who have been arrested and have been charged. All the freedom fighters can now go to court and be compensated. All the Gen Zs who were arrested and were jailed, you have still a chance. This authority is an authority from the Court of Appeal. So anybody whose the government has violated their fundamental rights, they can go to court and be compensated. Can they wait when a favorable government is in office for them to get compensation? Yes. Are violations of human rights time barred? No. The judges have said, the Court of Appeal, they are not time barred. Major General Kariuki waited for 23 years. Remember, he was sentenced under the regime of Moi. He never went to court under the regime of Kibaki. The Constitutional Court had not become strong. Welcome to the military weekend, where we are dealing with issues military, issues KDF, issues the Army, the Air Force, and the Navy. Do you know what happened in 1982? How many of you were alive or were mature in 1982? A coup happened in this country. And when the coup happened, the lawfully elected government of President Daniel Arap Moi was overthrown. It was majorly a coup led by officers, junior officers from KDA, from the Kenya Air Force, which led to very many Kenyans being killed. The army, led by Major Mahmoud, came from Langata and crushed what happened as a coup and reinstalled back the lawful government elected by the people of Daniel Toroitich Moi. Among the people who were arrested and taken to a court-martial was the Air Force commander, one called Peter M. Kariuki. We looked at Bramwell did a research and found the decision in the Court of Appeal at Nairobi, Civil Appeal 79 of 2012. This is the decision of Judges P.O. Kiage, K. Minoti, and J. Mohammed, all of them the judges of the Court of Appeal. This is the decision of March 21st, 2014. Peter M. Kariuki versus the Attorney General. This is page 1 of what happened. This appeal is an aftermath of an infamous event in the history of Kenya, as evident that happened some 32 years ago, and is aptly described by historian Charles Hornsby as Kenya's first true coup attempt. In the early morning of Sunday, 1st August 1982, non-commissioned officers of the Kenya Air Force mutinied and launched a bid to overthrow the government of the Republic of Kenya. After taking over the Air Force headquarters at Isli and their air bases at Embakasi and Nanyuki, they seized the international airport and post office and the national broadcaster, then called the Voice of Kenya. They even managed to broadcast to the country and the world that they had taken over power in Kenya. Within 12 hours of the mutiny, however, the tide had turned against the mutineers as they were swiftly routed out by loyal soldiers from other services of the Kenya Armed Forces, leaving in the wake of the coup attempt an official tally of 159 dead, mass looting and rape in Nairobi. Then the appellant's tribulation began. Paragraph 2. The appellant, Peter Mwagiru Kariuki, was the commander of the Kenya Air Force at the material time. At the time of the mutiny, he was at his farm in Timau, a few kilometers from Nanyuki. He had enlisted in the Air Force soon after independence and had received his commission as an officer in September 1965. He rose through the ranks, and by 14th May 1981, he was a major general when he was appointed the commander of Kenya Air Force by the then President of the Republic of Kenya. Paragraph 3. After the mutiny by his soldiers had been quelled, the appellant was soon thereafter arrested and confined for some time at Committee Maximum Security Prison, Nairobi. Subsequently, he was transferred to Naivasha Maximum Security Prison, where he was held in solitary confinement for 147 days. Paragraph 4. On 10th January 1983, Kariuki, the commander, appeared before a court-martial and was charged with the offenses of 1. Failing to prevent a mutiny contrary to Section 26A of the Armed Forces Act, Cap 199 laws of Kenya, now that is repealed, and 2. Failing to suppress a mutiny contrary to the same provision. The court-martial was presided over by Major General Lenges, with F.E. Aragon, then a senior resident magistrate, as the judge advocate. On 18th January 1983, the court-martial convicted the appellant of 2 offenses and sentenced him to 4 years imprisonment, the sentences to run concurrently. In addition, he was dismissed from the Kenya Air Force and stripped of his rank, benefits, medals, and decorations. Paragraph 5. For those reasons that are not readily apparent to us, the appellant did not challenge the verdict of this court-martial in the High Court, as he was entitled to do under Section 115 of the repealed Act. He therefore served his full sentence. After the Commissioner of Prisons, in a rather unilateral and summarily manner, declared that the appellant would not be considered for any remission of his sentence, matters rested there until some 23 years later, when on the 21st July 2006, the appellant filed a petition in the High Court alleging violations of his constitutional rights and freedoms regarding his arrest and trial before the court-martial. He prayed for the following declaration and orders and reliefs under the former constitution. What are we talking about? The commander-in-chief of the armed forces, the commander-in-chief of Air Force, was arrested and charged with the offense of treason. He was sentenced to serve. When he was sentenced to serve, he never challenged that sentence. Very strange. 2, the Commissioner of Prisons said he will not be given remission. Remission is when you serve, when you are sentenced, the prison will reduce a third of your sentence. Major General Kariuki was not given. After 23 years, he filed a petition. What is he seeking for? He is seeking under the new constitution that he must be compensated and that the act that was committed was illegal. What did the judges give him? What are the orders of the judge? In paragraph 102, the judges of the Court of Appeal said, "We have already adverted on the fact that the appellant filed this constitutional petition some 23 years after his conviction by this court-martial. We agree with the trial court that his claim was not time-barred. However, the consequences of the appellant's delay in lodging his claim was some level of prejudice to the respondent, who contended that the matters complained of by the appellant had taken place a while back and many of the actors were no longer available as witness. We have already emphasized that the right to a fair trial must be accorded to both the appellant and the respondent. Ultimately, We allow the appellant's appeal on the following terms. 1. Mr. Kariuki, the commander of Air Force, is awarded Kenya shillings 15 million shillings as damages for violation of his constitutional rights. 2. The appellant's conviction and sentence by the court-martial is hereby quashed. 3. The appellant is awarded Kenya shillings 22,965,460 being his salary, arrears and allowances. The appellant's, number 4, the appellant's rank, benefits, honors and decorations are hereby restored. The appellant is awarded costs both in the High Court and in the Court of Appeal. This is the judgment of the three judges. What is the import of this matter? We have very many young people who have been arrested and have been charged under the government of President Kenyatta, under the current government of President William Ruto. Can they wait when a favorable government is in office for them to get compensation? Yes. Are violations of human rights time barred? No. The judges have said, the Court of Appeal, they are not time barred. Major General Kariuki waited for 23 years. Remember, he was sentenced under the regime of Moi. He never went to court under the regime of Kibaki. The Constitutional Court had not become strong. He went in court after 23 years and he has succeeded in being compensated. Can you be restored the ranks? Yes, I repeat, this is a very fundamental judgment. Look, his salary for those years was returned back, 22 million. His ranks, benefits, honors, decorations were restored, and he was paid a compensation of 15 million shillings. What does this mean? All the freedom fighters can now go to court and be compensated. All the Gen Zs who were arrested and were jailed, you have still a chance. This authority is an authority from the Court of Appeal. So anybody whose the government has violated their fundamental rights, they can go to court and be compensated. Wakili Danstan Omari,